Yeah, we're live now.
Hello, hi, welcome, and very good morning to all. And welcome back to Cyber Talk with Cyber GRC podcast. Today, we are honored to welcome Arzu Chimni as distinguished corporate and technical lawyer with over 15 years of experience in privacy and regulatory landscape. Arzu is currently a part of Data Fiduciary team at Obhan and Associates, where she advises Indian and global organization on navigating the complying with the DPDP Act. Her professional journey span over top tier law firms as well as in-house legal role within multinational corporation. Over the years, she has supported global brands and innovation-led companies across sectors such as technology, consumer goods, media, digital services, and guiding them through complex matters of data protection, IPs, IP strategies, regulatory risk, and product compliance. We are excited to have her share her deep insight and practical perspective with us today. So we have some scenario-based legal questions and some FAQs that is frequently asked question. So my first question will be that is most people ask is the DPDP Act already in force, and when do we need to comply?
Thank you so much, Vidya, for that lovely introduction. You're being very, very kind. You are absolutely right. There's a little bit of, for the layman, there's a little bit of confusion on the implementation of the DPDP Act. So, Love and I have already had a conversation on this earlier on the fact that this act was actually passed in 2023, but they hadn't passed a notification and the rules to operationalize it. Right now, what they've done is that a couple of weeks back, they have released a notification operationalizing the act, and they have also passed the rules. Now, what does this mean? They have laid down clear guidelines. So, as I said, they have come up with supporting rules that actually lay down the specifics and the procedural parts of how you implement the act. And what they've done is they've given it a phase-wise implementation schedule. As of now, they have said that they will immediately set up the Data Protection Board of India. So, what this will do is this is the body, the regulatory body that will oversee any matters that pertain to this act. So, that they are going to set up immediately. They have also issued a notification saying that this body will have 4 members and that the appellate body will be the TD Act, which takes up telecom matters as well. What they have done then is there is a concept of a consent manager who's a person or actually an organization that's going to be a conduit between a person and a data fiduciary. So tomorrow, if I go to a company and I want to know where all they're using my data, uh, how I have given my consent, what the details of my consent are, where I've said yes, where I've said no, what the conditions are, I can go through this consent manager. Now, these companies have to register as consent managers, which will start in 12 months. So, I think the date is 17th, I think they came out. So, oh no, the 13th they came out. So,
13th
13th
of
of
November.
In
Yeah,
November.
yeah,
yeah,
yeah, yeah.
13th of November next year is when the registration and all the provisions pertaining to consent managers will come into force. After that, they will wait for another 6 months. So that comes to, I think, about mid-May, when the rest of the act will come into force. So what we are talking about is that the parts pertaining to the rights of data principals, the obligations of data fiduciaries, all of that, we have 18 months to comply with. This gives organizations some time to get their processes in order. And processes are still slightly simpler. It is the data mapping which is taking time. And in fact, I'm sure you know it is taking months and months for organizations to track where they have been keeping their data, what is personal data, starting with the basic understanding of that. There are times when you don't know which team has been collecting what data because they start doing it independently. That's very commonly seen in companies. So they have about 18 months to tackle these issues now. What they have done
Okay.
immediately is that they have made certain amendments to the RTI Act, which are immediately applicable. So those are applicable as on date. So yes, that about covers it.
Arju, one question I had on this. So let's say companies now have to start their processing towards this act. What is the first step they should take actually?
I think it's very important when you have to get your house in order to first
Yeah,
have all the information. So I
right.
think you start with a very, very basic understanding where you explain to your people what personal data is, because that is a problem we've been facing when we are doing our compliances, and start with the data mapping. It's a very, very good starting point. After that, you can explain to them, so when the I had seen this when the POSH Act came into play, the Prevention of Sexual Harassment Act, because the liabilities were so high and the responsibility rather was given a lot of importance. Organization took steps from top to bottom to ensure everyone is trained on it, everyone understands it, and it was a little tricky to understand what it covers and what it doesn't, because a lot of it is uh, based on an understanding and of, or rather interpretation of the people involved, right? So there I saw a very, very wide effort to ensure that everyone understands it. So why I'm giving that as an example is to say that here also we need to see those steps implemented from top to bottom, and understanding being given from to everyone, right from the top level to someone at the lowest level, because your one employee might do something that you will be held liable for. You cannot tomorrow say that I wasn't aware of. So yeah, that is something I think that is extremely important.
Thank you, thank you. Yeah, and I completely agree with you on that, Arju. Absolutely correct. Yes. Yeah, go on with that.
Okay.
Yes, sorry, what would you like?
So for
Yeah.
this, I'm sorry.
Go ahead,
No,
Vidya.
no, please carry on. Go ahead.
Yeah, Arzu, you were saying. Acha, okay, yeah. So for this case, we have a scenario-based legal question. Is that uh, our HR team shared employees' phone number with an external wellness vendor without informing staff? Does this count as unauthorized processing, and what penalties could we face under this DPDP Act?
So absolutely, uh, that is a very big issue because phone numbers do amount to personal data. There, see, there are cases where people are arguing in certain cases it does not amount to personal data. Then you go into the concept of anonymization and pseudonymization, which I doubt will be the case here, because you will just pass it on with the names so that that company can contact them. So that is a huge lapse unless you take consent from people to say that we will be sharing your data for this purpose, what it will be used for, and you give them all the necessary details. As far as the penalties go, I think the minimum penalty under the act is about 50 crores and it goes
50
up to
crores. Yeah, 50
250.
crores.
Yeah.
Yeah.
And 250 is for security measures to be put in place. So right now, since these provisions haven't been interpreted, I'll go with 50 crores, but we don't know how the 250 crores will be interpreted as of now.
So I just
Okay.
have a question here,
This
Arzu.
is for
Maybe
all our listeners.
I think
okay.
Jayant had a
Yeah,
question,
yeah. I had
Vidya.
a question. Like,
Yeah, please,
what
please.
made India to introduce this law at this moment? Like, how it was before? So, most of our listeners might have this question,
Mm.
right?
I think it was the need of the hour. So India as a, I mean, we are we are getting stronger where the world stage is concerned, and we do have a lot of business relationships, although that's a bit tricky at the moment. Uh, but it's very important to have some sort of parity. Now, the EU already had the GDPR. Um, a lot of other countries, for example, Singapore had something very similar. The US has different states have their different laws. The UK has their own DPA. So it was very important for us to be at par, because as it is, when our companies do interact with them, they have to adopt them. So I think for a lot of those companies, it was very, very important to do it. And I'm really glad that India has reached a point where, so previously or rather even now, we have the IT Act. So the IT Act was very based on if something goes wrong, you can after go after the company, but otherwise it was more targeted to. It wasn't very rights heavy. Now, this for the first time, you're essentially telling your people that you are the most important factor here. You have control over your data, which is very, very important considering how data heavy our economy has become.
Okay, that's a great point. Like to say in other words, like principal data principals have been given a more power
Absolutely.
to hold on their
Absolutely.
data. Good to know that. Thank you. Go ahead, Vidya.
This is for all our listeners. Whoever have any query or any doubt, feel free to ask us, because this is all for only for you guys. So next frequently asked question we have is, do we need to appoint a data protection officer?
So like now the government, so there is a concept of data protection officer and there's a concept of a point of contact. You definitely have to have a point of contact who's aware of the rules and regulations and the timelines and who has to respond accordingly. That person should be able to answer your questions, give access to your rights, update your information. So you have your point of contact. What you do have for significant data fiduciaries is they have to have a data protection officer in place. What a significant data fiduciary is, what the criteria is, we don't have any information at the moment. So that is something we'll have to wait and see. But yes, for all practical purposes, whether or not you are an
Okay.
SDF, you have to have an officer. You have to have a point of contact in place.
What is the difference between a data fiduciary and a data processor?
Uh, So this, while the definition is very easy, gets a little tricky to interpret at times. A data fiduciary, I would say, is someone who collects the data, someone who's in control of the data. Now, if they have someone who's collecting it on their behalf, and they are the ones who are deciding what it is being used for, and things are essentially in their control, that is when that person is a data fiduciary. So what I like to do is don't look at the point of collection, look at who is controlling the purpose of the data, who is instructing, whose instructions are being followed. That is how I would say the data fiduciary should be identified.
Okay. And what about a data processor?
Processors process data under their instructions. So you have your, someone who's giving a backend software to you, someone who's helping you. So you have a lot of these SaaS platforms, and those would essentially fall within the category. You have your HRMS, you have your ERPs. So anyone who's helping you process the data, helping you collect that data, they will all come under the definition of a data processor.
Okay. We have a
We
question.
have a question. Yeah.
Yeah.
So to my
Hello. Is
mind,
consent
it would
manager?
have to be, yes, sorry, Vidya.
Yeah, please, ma'am. I guess you it.
Mhm. So to my mind, a consent manager will need to be an organization because there is certain criteria regarding revenue that has been put in place. It talks about there not being a conflict of interest where directors are concerned. So it'll need to be an organization that will need to be registered with the Data Protection Board of India.
I think Arzu, the minimum revenue is 2 crore they're targeting at, right? For this,
Yes, yes,
yeah. Okay.
absolutely.
Thank you.
So having
Thank you so
this
much,
act, I
Prashant, for
think
your
this
question.
is going to impact on Indian digital economy, if I say,
Yes,
right?
absolutely.
Okay. Go ahead, Vidya. Go ahead with the questions. Yeah.
Yeah, as we have the concept of consent in DPDP Act. So, what exactly qualifies as consent under DPDP?
I think there are a lot of, if you look at the theory of it all, there are a lot of there are a lot of details that have been given on consent and what form your notice should be in. Essentially, the most important word to keep in mind is transparency, and you have to be very clear on the details you give it. You give the data principle. You have to tell them what you're collecting, why you're collecting it, how you're collecting it, what purpose you're collecting it for, and give them details of how it will be used. So you have to keep all of these details is what you need to inform them about. Now, once you inform them, their consent has to be informed, and it has to be through affirmative action. So something as simple as a checkbox that they have to tick, they have to say, I accept. It cannot be something that you give them just a notice for and then say that I have done my job. You have to make sure that there is an affirmative action that happens that is how you take consent. And one very interesting
Okay.
provision, in fact,
What?
is that sorry, Vidya, I think there's a slight lag actually.
Yeah, yeah, she
So
has, she
one
has.
very
Yeah.
Mhm.
Yeah, so one very interesting provision is that they have said that this notice, where you're giving information to the data principal, will need to be made available in the constitutional languages. So that covers, I think, about 22 languages, and that's a very interesting provision.
So it's a regional languages, right? All the regional languages are covered, I
Yes,
believe. Yes.
yes, and it's a long list. So
Yeah.
This is
And
the
it's
important
a
point we should know, I think, as a principal, data principal, having like consent given using their own language, most important, right?
Yes, it's very important, and the government is definitely going for information being accessible to everyone, and every data principal should know that they have this right, and every data fiduciary should know that these notices need to be ready in those languages. So,
Interesting.
What counts as lawful purpose without consent?
lawful purpose ends up being so there are a couple of legitimate uses that are covered under the act. Lawful purpose, according to me, that it's so there is a little bit of an inconsistency between the sections that cover lawful consent. So, sorry, lawful purpose. But essentially, it is something where you're using the data for exactly the purpose it has been given, and you limit it to that. So, my understanding would be that it is being deleted after that. So, yes.
Yeah, we have a question from Akhilesh.
I can't read the full question. If you could just read it out to
go ahead
me.
with the, yeah.
Which sector will be most impacted with DPDP Act and how does their compliance differ?
I think all sectors will be very highly impacted. Everyone, right from an e-commerce, a person selling things on their website to anyone collecting information. Then you have banks who collect a lot of information, financial institutions, hospitals, real estate companies that collect so much data. So I think everyone across the board will be affected. There are some companies that so B2C companies will be the most affected. B2B companies will also have their employees, so they will also get affected. So they have to put the provisions in place. But people who collect a very large amount of data, I think, will be the most impacted. And compliance should be the same right now since we don't have a definition for significant data fiduciaries at the moment.
So with this, Arzu, what I understand, like irrespective of the
Yes,
business size, it will impact all the businesses, right? So
yes.
in this case, how the small businesses should cope up with the compliance, DPDP Act compliance, basically.
Uh, I think they should understand it's very important for these organizations to understand that you have to be responsible with your data. So I feel they should start with their data mapping, put the relevant legal documents in place, give trainings to the relevant people. And once you have your data mapping in place, I don't think consent should be that difficult as long as after your data mapping is done. So your historical data is all covered. After that, it's a matter of training your people and just putting necessary procedures in place. So it's the data mapping that's a little tricky. So one more thing I would tell smaller companies is please don't collect unnecessary amounts of data. Um, All companies used to earlier feel data is king. So that is not the case anymore. You really have to limit the data you collect. And I think that's the most important need of the hour. This question that I'm reading, passport is SDF or DF? I'm sorry, I don't understand that question.
Significant data fiduciary or data fiduciary, they mean.
No, no, that I get. But like passport, what does it mean by, because passport is my data, right? So
Yeah.
do they
So
need
they
a
are saying,
passport? Okay.
yeah. So they are saying if somebody collects their passport information, so will that company come under as a
Okay.
significant data fiduciary or data fiduciary?
Okay, got it. So, your passport is your personal data. It definitely falls under that definition. If you collect it, that won't automatically define whether you're an SDF or a DF right now. But we don't have more information on what qualifies a data fiduciary as an SDF. So I don't have an answer for you at the moment. We'll just have to wait and see for when the government notifies the relevant criteria.
Harzu, since you said like data mapping is very critical here, can we just have more information like what is data mapping altogether here?
Mm, I think you identify, how I like to do it is you start with identifying what personal data is. Then you see where you're collecting personal data, what you're doing with it, who you're giving it to, whether you're deleting it or not, and how you're treating it. So I think you have to capture the whole life cycle of the data you have and see it from the present day till although they are saying the act is not retrospective, that is a clarification they had issued, um, which means retrospective would mean that it is not applicable for things of the past. It is only applicable from the date. But if you use that data for a new purpose, a purpose you had not covered in the past, so earlier also under the SPDI rules, you had to give a notice. Sorry, you had to give a privacy policy, not a notice. And for certain data, there were some additional criteria. So now, if here is where there's a slight difference in interpretation. Now, it says if you have taken consent in the past. Now, whether that means you have taken affirmative consent in the past or you just had a privacy policy, that's a little open to interpretation at the moment. But I hope that answers the question, although I went a little roundabout
Definitely.
on it.
That's a pretty
So
much
I
of
hope that helps. Otherwise,
information.
happy to give any clarification that you need.
Looks good enough. Yeah. You just got a brief about it. Yeah. Go ahead, Vidya. You have a questions?
Next frequently asked question we have is, yeah, next frequently asked question we have is, okay, we have a question from Ash.
What is the effect on the DPDP Act when the data like CCTV is provided under the RTI Act? Whether government organizations have special privileges in the DPDP Act? So let me start off by saying government organizations do have a lot of special privileges and exemptions under the Act. They can process your data um, for purposes of giving some benefits or for in the interest of the country. I'm oversimplifying the answer, but essentially government organizations do have special privileges. They can access your data, they can collect your data, they can ask organizations to supply your data. So all of that is there. The second part where you've spoken about the RTI Act essentially, there was an exemption under the RTI Act that talked about you that personal data did not have to be supplied as long as there were two conditions. As long as, sorry, not as long as, unless it is something that they would have had to produce as it is in front of the parliament or a similar body or a legislative body. Or the second thing was if it was something in public interest. So personal data is an exemption. They don't have to provide any information under RTI for personal information. But there are two sub exemptions to that, right? Now, as I said, as on date, with immediate effect, one amendment to the RTI Act has been made where the remaining part has been deleted. So now personal data, personal information actually, is a complete exemption. So under the RTI Act, if something amounts to personal information, it does not need to be revealed anymore, even if it is considered under public interest, even if they would have had to produce it before a legislative body. So when you're talking about CCTV, I don't know what example you're talking about exactly. But if it does fall under the RTI Act, then it is completely exempt.
Thank you so much.
Should I
Suresh
go with
is
the next
asking
question?
yeah, how does the DPDP Act address cross-border data transfers?
Hmm. Right now, it they have not notified a negative list. So as of now, there are no restrictions. But they could notify countries to which you cannot transfer data in the future. They've kept that power with them.
So I think before we go to the next question, basically I think
Okay,
there is one
Inderdeep
important
Singh is
question.
asking
I
how
have
will
it. Hold on, Vidya. I just wanted to understand, like, what is the measure government has taken to educate a normal citizens? Because all this act is very tough for individual to understand. And what is that measure government is taking on this
I
aspect?
I am so sorry. I didn't get that there. Could you repeat it? Your voice is
Okay,
breaking.
okay. This being a very critical information for a normal citizen to understand, I just wanted to know what is that action or the program that government has taken to educate the principals or the data holders.
Mm, I don't think they've taken any measures to educate data principles at the moment. There is an increased awareness in general, but nothing at the moment from the government as an initiative, to my mind.
Okay.
Although I do defer to you in case you're aware of any such educational or general information measure that has been taken by the government.
Okay, okay. Yeah, we have a one more question.
we
Go
have
ahead.
a
Yeah.
question from SK. Which job roles will emerge fast due to DPDP Act?
Okay, so your question is, I think there will be a huge requirement for people who are aware of the act. You need to put DPOs in place, your data protection officers in place. You need to have points of contact who understand the DPDP. Consent managers will be a very big avenue of a new sort of company that will need to be formed, and employees who can fulfill these roles will definitely be in demand.
Okay, thank you so much. We also had that one question from Inderdeep. Yeah. How an ERP system like Oracle, Microsoft companies can comply with internal controls for data privacy?
So I will just be able to cover the legal side of things and say that under the Act, there are requirements for reasonable safety, safeguards to be put in place. So that will definitely need to be complied with. They will need to comply with all the obligations that fall on them under the Act. As far as internal controls go, I think Love and Jayant will be in a better position to answer that from a technical point of view.
Yeah, basically, for the internal controls, already companies are following ITGC as their main controls for now. And mostly when it concerns with the privacy and personal data, I think controls like encryption and pseudonymization, like you already mentioned, also are the ones that they have to opt out for. Like they can't use the person that data directly, definitely. So those are the things that will definitely help the organizations in terms of controls.
Yeah,
Suresh,
there is another
again we
question.
have
Go ahead, Vidya. Vidya. Yeah.
how can organization ensure compliance with the
I just
DPDP
wanted to
Act?
check if you can hear me properly
Yeah,
because
yeah.
when all of you are
Go on,
speaking, there's
Arzu.
a slight lag for me.
It's okay. You're good.
So there was a question from
All right.
Suresh. How can organization ensures compliance with DPDP Act? Arzu, you're able to hear us?
Yeah, sorry, I think there was a slight. I can hear you.
Okay, okay. I was just reading out the question
Yeah.
that we have it on the screen. Yeah, go ahead, Vidya.
So Suresh is asking, how can organization ensure compliance with the DPDP Act?
Arzu, are you able to hear us?
Okay. So there are quite a few obligations under the GDPR Act, but as you said, you first. I can hear you. Is there a problem with my connection?
Yeah, looks to be there
Yeah,
is some
looks to be
issue.
laggy. Yeah, some lag is
Yeah.
there. Yes.
Let me just.
Guys, keep on posting your questions till the time Arzu is coming back. And Vidya, we do have a lot of questions, so I think we would focus on those only for now. A lot of people are back to back; they are
Yeah,
asking
sure.
questions. Okay, I have
Mm.
around 10 to 15 questions in pipeline for
Right.
now. Okay, so I think everybody was waiting for Arzu to come on board today. Everybody seems like very excited.
Yeah, the kind of questions we have it's all very valid. Yes, very valuable as
Yes,
well.
yes. So hold on, Neeraj, Suresh, Ramarao. We can see your questions. Let Arzu connect back. Then we'll get back to you one to one. Yeah, Arzu, are you back? Can you hear us
Okay.
now?
I'm back. Hopefully, this will be better now. Yes, I can hear you.
Looks better.
Okay.
Go ahead. Yeah.
Okay. Yeah. So Suresh is asking
Yeah.
how can organizations ensure compliance with the DPDP Act?
As I said earlier, you start with data mapping. Then you need to put. It's very important once you're done identifying what data you're collecting, what you're using it for, where is it going, how you're putting security measures in place. I think first is ensure security measures are in place. So start with that, the technical side of things. Protect the data, ensure that there are no breaches, and then you start with firstly consent. So you once you have the information you provided to the data principals that you're collecting the data from, if you had not taken data from someone in the past, you send them a notice saying what you have with you and the fact that you will continue to process it and you have been processing it. Once the consent and the notice part is over, you ensure that it is used exactly as per the information you provided to the person in accordance with the consent they gave you. Then once you have the data, you have to ensure that it is protected in the right manner. You have all the reasonable security safeguards in place that have been specified under the act. Once that is in play, you also, additionally, make sure that your data processors have all of these conditions in place so that they can process it uh, without being not in violation. So they have to be in violation as well. I think that about covers it. You make sure that you have a person in place who can be a point of contact for these data principals so that if they need to modify the data, they want to delete the data, they want to access the data, they have all of that. If there are any breaches by chance, You need to make sure you have your reporting mechanisms in place, because that is something that provides that you have to inform the data principals immediately. You have to give details to the board immediately. Then within 72 hours, you have to be able to give them details, extensive details regarding the point of breach, what the possible repercussions should be. So when you have to give the board details, there are quite a few things that you have to give them within 72 hours. That can only happen if you already have that mechanism in place. So you have to be very organized with your things. You have to be very transparent. I think that will really help you be compliant with the app.
Okay, we have one more question from Prashant. Who can become a concerned manager? Which tech standard is certification needed? What's
So
text?
at the moment, there is no certification, but you will need to be registered with the Data Protection Board of India, which will start in a year. So on November 12th or 13th, it will start. So that needs to be there. Where consent managers are concerned, there are quite a few conditions. In fact, I'm just looking at them. You have to be a company that's incorporated in India. You have to have sufficient capacity. You have to be in a good financial condition. You cannot have a conflict of interest with any company. And there's a shareholding that has been given for this. I think it's a 2% shareholding that you cannot have more than that. You can't have a connection with any data fiduciary. Then, as we already covered, you have to have a revenue of over 2 crores. So the government is trying to ensure that one, you're an entity that is sound and can continue. You're a healthy organization. And second, you're registered with the Data Protection Board and capable of carrying the business. So capable of carrying on the business without there being any bias.
So Arzu, here the previous question, to be a consent manager, the company has to be a private limited or a public limited, or we have any specification on that?
Mm, there's nothing given at the moment, but I'm
Okay,
assuming it will be yeah. Yeah, there's nothing given at the moment.
okay, okay. Thank you.
Hmm. Next question we have from Neeraj Pandey, who is asking how much volume is big enough to categorize data fiduciary as what is SD? Like SDF. I don't know its full form. I'm sorry. Uh,
Significant data
is
fiduciary.
there any
Yeah.
numeric data volume? Okay.
I
Is
can see
there
that everyone's very
any
curious about
numeric
this.
data volume?
Yeah, everyone seems to be very curious
I'm
about this.
sorry.
I'm sorry, but there is nothing that has been defined at the moment. There is no numeric data volume.
Neeraj is asking again if data getting transferred across cross border, on what basis it decided what privacy law prevails, DPDP or other country.
So here is where there could be a possibility that both laws prevail. Both laws are applicable where Indian data is concerned, data of Indian citizens is concerned, where data pertaining to any of any goods or services offered in India is concerned, the DPDP is applicable. Similarly, the EU is very clear that where there is anything to do with an EU citizen or an EU organization, the GDPR is applicable. So, depending on the law of the country, depending on where your data is going, which citizens it is dealing with, where your services and goods are being offered, you could actually have multiple laws that are applicable.
Yeah, go ahead. We
Yes,
have a question
JK.
from
I'm
Ram
very
Rao. Go ahead.
glad
Yeah.
that I got trained. I am very glad that I got trained on GRC basics and ISO 27001 by Love Johar. What additional skill, technical and non-technical, would I require to work in DPDP compliance?
Love, I think you will need to answer this.
Yeah, basically, Ramarao, there are many technical aspects to the act as well. Like people are asking what controls organizations can implement in order to safeguard the personal data. That is where need of a technical staff like a data protection officer will be in place, definitely, for the organizations, and that is a very good role to opt for, right? Arzu, you would agree with that, right?
Absolutely.
Yeah.
Suresh Pant is asking, what are the obligations regarding data breach notification?
I think first and foremost, what you need to do is you need to inform data principals on what on there has been a breach, what data has been accessed in the breach, and what the possible repercussions should be. You have to inform the Data Protection Board of India that there has been a breach and similar. Um, See, this will be a preliminary notice that will go to the Data Protection Board, but within 72 hours you have to give them details of, as I mentioned earlier, of where the breach has come from, what has caused it, whether they have taken any remedial measures, what measures they have put in place to ensure that this doesn't happen again. If there is any employee or person who has been the point of the breach, you have to report that. And you have to also report what the status of informing the data principals is. So you have to ensure that you have already informed the data principals before these 72 hours. So you also become a data principal under the breach if your data has been breached. So that is also something that the companies will need to do. So it's a very, very short timeline. You need to identify the breach, see what data has been breached, whose data has been breached, inform those people, inform the Data Protection Board of India, and then within 72 hours, give them all details. So, yeah, those are the obligations you're going to have in place.
Thank you, Arzu. Questions are still piling up. Next question on children's data we have.
Yeah, Prashant,
Uh,
any clarity on children's data?
There was a lot of confusion earlier when the rules hadn't come into play because they say that where children's data is concerned, you have to ensure that verifiable lawful consent of the guardian of the child has to be taken. Now, there are a lot of cases in which children's data is collected and there was no surety on, or there was no clarity on how they will ensure or verify that the person is indeed the lawful guardian of the child. Now, what they've done is they have clarified that you can link it to something like, as an example, they've indicated towards the DigiLocker that you can link it with that, and that is where mm, you can verify that your consent is correct consent and that the person is indeed the parent or the lawful guardian of the child. There are certain exemptions that have been given. What they've done is they've given a schedule under which there are certain exemptions. So one part is that you have to ensure that this consent is taken. Then another part in the act stated that you cannot use this data for behavioral tracking or any other tracking of the child. The exemption states that in certain cases you are allowed to track the child without taking consent. And those are simply, there are sectors like healthcare, education that have been given exemptions, but those exemptions are under very strict conditions. And they usually, most of them are linked to the safety and the interest of the child.
Mhm. Okay, next question is, the organization has already collected the PII data and going forward, how this risk shall be considered and how DPDP helps with this to take this up.
Sorry, give me a second, something has come
Yeah,
up.
yeah, sure, sure.
Sorry, I just needed a second. I'm back now. The organization has already collected the PII data and is going to collect going forward how those risks shall be considered and how DPDP helps with this to take this up. So earlier you had the IT Act and you had supporting SPDI rules which divided it into personal data or information, and then you had the uh, suddenly I'm blanking out on the full form of SPDI, but it was
CDP.
sensitive personal data or information, right? So that covered your medical information and your financial information, amongst others. But for simplification, I'm referring to these two. They were bunched into two groups. One required a privacy policy, the other required consent, right? Now, right now, the IT Act is still in play. So you have to follow the IT Act and the SPDI rules where these are concerned. Once in 12 months, in 18 months, when the SPDI Act will no longer survive because the DPDP Act will overrule that. And that has been made clear because the power of the government under the IT Act to make rules towards personal data has been removed. Since those powers were used to actually put in place those rules, the SPDI rules, to my mind, they will get um, they will no longer be in play. They won't be in force any longer once the DPDP Act is notified or is implemented. When that happens, all personal data is going to fall under one bucket. So you will have to have these compliances in place for everything. After that, there won't be a need for segregation of PII data, SPDI, and things like that. So it will all fall under one bucket. But right now, for the next 18 months, you still have to comply with the SPDI rules and the IPI.
Okay. Arzu, for all the organizations who are
Now,
watching this,
just to
yeah,
clarify here, the IT
yeah,
Act will still remain in force after 18 months also. It's only provisions pertaining to personal data, for which you will now go to the DPDP Act.
right, right, got it.
Okay.
So, for all the organizations who are watching this, or all the professionals who are watching this, at what stage should they consult somebody from somebody like from Obhan and Associates, or from a legal perspective? What will be those scenarios? Will it be training perspective? Will it be awareness perspective, or will it be actually to make them understand more about this law? What will be those scenarios?
So right now, we're getting queries from a lot of people in general. So I'm basing this on what is happening, what I'm seeing practically at the moment. We do have people coming to us with questions, opinions, and general clarification on what is needed. We are also getting organizations coming to us with to form a plan for them of implementation, and we're making plans for them on the technical implementation, which is a part that we don't necessarily take up. Um, it's more on the legal compliance of things, helping them ensure from a legal point of view that the data is segregated and helping them identify what personal data is, I think, and training their people on the basics of understanding this law and putting those procedures and necessary documentation in place. I think that is that is summarily what we.
Yeah, because I think that is more important from an understanding perspective rather than
Yeah.
going for a technical implementation. First, we need to understand what the act is actually about. So yeah, definitely.
Yeah, so I'll give a slight, there's a slight difference there. So from implementation point of view also, there are two buckets. There is the technical and there is legal. So implementation point of view also, I think you need to ensure that your legal compliances are in place along with your technical compliances. So it's very important that both go hand in
Okay, so in legal compliances, you
hand.
mean to say all the documentation in terms of the
Yes,
act, in terms of policies, consent forms, and everything, right?
absolutely. Exactly. So even something as simple as a manual or an SOP, you have technical manuals and SOPs, and then you have legal manuals and SOPs. So everything has to go hand in hand.
Right, right. So I would say a great amount of understanding definitely is needed at this time of the hour, especially for
Absolutely.
organizations. I would say more in the private sector, and more in the high critical zone areas, for example, banking, healthcare,
Yeah,
employee recruitment agencies, where actually they are dealing with huge amount of personal data. That is where we will see more of this coming up.
absolutely.
Right.
Okay, do
So we
we
have
have
another
We
any?
have
question.
other
Yeah,
questions here.
We have many
yeah.
questions. Don't worry.
Mm.
Yeah.
Suresh Pant is asking, how does the DPDP Act 2023 define personal data and sensitive personal data?
Uh, it actually doesn't. The IT Act defined it. So here you just have personal data, which is defined as data pertaining, I'm just oversimplifying it, but data pertaining to a person. So that is all. There's a single bucket.
Right.
Inderdeep Singh is asking, could you please give an insight on the penalties or fine if they're adhered to DPDP Act? If
Uh,
not,
so,
yeah.
I
so
think
I
more
think
than
most
implementation,
important
this
one
is
there,
what industry is concerned about. Fines and all.
hopefully,
Right?
you'll always go for,
Right.
I feel you want someone to follow a law, put in place a fine.
Fine.
That is
That's
actually what works best. So
right.
here, I think everyone's worried because the amounts are very large, and under the GDPR, it's linked to revenue. Here, they've not given any direct linkage. They just have blanket amounts. So I'm just looking at it where there is a breach in taking reasonable security safeguards. It is 250 crores. Then you have things that go to 150, 100, and then 50. Essentially, any non-compliance, even something as basic, they've given language as wide as saying that you're not in compliance with your obligations, which can be very widely interpreted, could also lead to a fine of up to 50 crores. Another thing that I found very interesting is that the 250 crore provision is not linked to an actual breach happening. It is linked to a breach in your reasonable security safeguards. So it doesn't mean a breach has to happen. It is a breach in you observing. So it's a breach of compliance.
Okay. Next question is, how should we clarify legitimate uses versus consent based processing?
Uh, so you have your consent-based processing for which you need consent, and then you have uh, purposes, and then you have uses and then you can use personal data in certain cases where you do not need consent. A couple of places where you can use it is where the person voluntarily gives their data. Now, voluntarily hasn't been very clearly defined, but there are certain illustrations and examples that have been given in the act. So, for example, you go to a store and you tell them, okay, send the invoice to my phone number. They can use your phone number to send that invoice, but not anything beyond that. So that would be voluntary and a legitimate use. Then what it would also include is using your employees' data for employment purposes, but again, you have to interpret that very strictly because under law, employment purposes is very strictly defined as not under the act, but generally under law, Indian law, it is defined as strictly employment purposes. So that would not include, for example, if you have an off-site or a holiday you're going for, I mean, through the or business travel that you're doing, any benefits you're giving. So ideally, I would say go and take consent for employment data. Then you have for research and archival purposes, you do not need consent. So those also, all of these come under legitimate uses. And then, of course, you have information being given to courts for execution of a court order. You have government for benefit purposes for them to give benefits. So things like that.
We have a lot of questions still lined up, Arju, but I am considering time as well, because we had this for 1 hour only. So I would request everybody to keep on commenting on the post, and we'll get back to you on the questions. Okay. And anything you want to add, Arju, before we conclude the session?
Uh, I
Yeah,
think we've covered a
at the
fair bit,
end. Yeah.
and it's been a very, very interesting conversation, to say the least. I I think I've enjoyed the questions that have come from people because that shows what is clear and what is not clear to people. For now, I would just tell everyone, one, if you're a data principal, be aware of your rights because this is heavily in your favor. Uh, that actually opens up avenues for misuse, but I'm hoping people don't do that. Then the second part is if you are an organization, then a couple of things. One is transparency, and second is please be very organized where your data is concerned. Do not use it or collect it unnecessarily.
Right, right. Thank you, Arzu. Over to you, Vidya.
Thank you so much.
Thank
Thank you, Arzu.
Thank you so much for joining us today. And a special thanks to Arzu Chimni for sharing her expert insight and breaking down complex DPDP Act requirement with such clarity. Her experience across global organization and diverse industries truly brings a practical lens to privacy compliance. We hope today's discussion helped with more confidence and understanding. If you enjoy this episode, don't forget to follow, subscribe, and share it with your team and peers. This is the CyberGRC podcast, and we'll be back soon with more conversation on privacy, AI governance, and digital trust. Until then, stay compliant, stay secure, and keep learning. Thank you.